Juvenile law is another aspect that's really going to be looked at closely. If a child's charged with a crime, it's a little bit different than an adult, but the child still is the attorney's client. With juvenile law, a lot of the time the courts want to do things that they say is best for the child, but they're not giving the child the same protections, even though they're supposed to, that they would for an adult. You want to make sure that a child doesn't have a case resolved that's going to impact them either in the present or in the future. And a lot of the time the courts think that they have the child's best interest at heart, but if you have an attorney that actually does juvenile law, they're much more able to go over whether the Commonwealth or the state has enough evidence to convict the child, whether the case can really go forward or not, and also make sure that the child not kind of caught up in kind of a bureaucratic system where there's court clinic evaluations, even if the child doesn't really need to go see a court clinician, where there might be DSS or DCF referral, even if that's not needed as well, or conditions that are prohibitive to really what the underlying issues are. You also see a lot of times judges and prosecutors and probation officers that in adult court might be looking more carefully about whether or not they meet the statutory elements of the crime. In juvenile court, a lot of times they're just saying they want to get this family help or this child help, and are really trying to push to get a case resolved. And you want to be careful, and you want to make sure that again, even if the child did what's being alleged, that there aren't any motions to get things excluded or to get discovery or to dismiss because of lack of probable cause that can be put in place. And you want to make sure, are the witnesses against the child, are those going to be reliable witnesses and things of that nature. And a lot of times people in juvenile court have that expectation that people should just resolve the case and that everyone's working towards the child's best interest, which may or may not be the case. But as a defense attorney, my perspective is very rarely can the court provide something that you as a family member cannot. That if the child needs therapy, you can get the child into therapy. If there's family therapy, that can be put in place. If there are other services that can be there, it's much better for the family to do that rather than the court to make that a condition. Because if the court makes it a condition and it's not followed, what can end up happening is the child can get found in violation of probation, and you see it all the time where the child either gets held at DYS for a weekend or a week, or even committed to DYS, and things can spiral out of control over things that are starting out where the child has a pretty good case to win at the beginning, but because they get conditions anywhere from curfews and no contact with friends that they have who might be defendants or girlfriends or boyfriends, the things have to be looked at fairly closely. And I think the children really do need an attorney that's not just going to have them resolve the case as a first step.